Everybody. Okay, so chapter 4, civil liberties. So one thing to note here, guys, is that the freedoms in our country, the liberties in our country have undergone major evolutionary changes between when our country was first developed until our modern day administration. So, for example, the establishment of the Jim Crow laws was ruled as legal by our Supreme Court system, okay, back in the 1800s. To know this case as Plessy versus Ferguson. So this case basically stated that segregation was legal as long as there were equal accommodations. So our Supreme Court has played a major role in the evolution of our civil liberties. Reason why I say that, fast forward over to the 1950s, Brown v. Board of Education, the Supreme Court then said that separate accommodations were not legal because they were inherently unequal. So what you'll notice as we're going through this and as you're going through your assignments, the definition of things that are socially acceptable has completely changed over time. And as that have changed, so has the rulings of our Supreme Court. And you'll see that the Supreme Court rulings really mirror what is acceptable and unacceptable in modern day society or in society at the time when the ruling was delivered. Okay? So, civil liberties. These are specific individual rights, such as the right to a fair trial. They're constitutionally protected against infringement by the government, meaning they cannot be taken away. And they are constitutionally protected under this Bill of Rights. Now, the Bill of Rights are the first 10 amendments to our Constitution, things like freedom of speech, freedom of religion, right to bear arms, all those different things. These are all part of our Bill of Rights, okay? They're rights that cannot be taken away except under very special circumstances, which we will get into. So, the 14th Amendment is also part of this civil liberty idea in our government. Reason being is that the 14th Amendment has guaranteed the right to equal rights under the laws. Okay? This made it so that each state, whether it be a southern state or a northern state, had to make sure that all of their laws, all of their rulings were honoring somebody's or a group's right to be considered an American citizen and right to be able to enjoy liberties from being an American citizen. Okay? And we have also seen this in selective incorporation, invoking the 14th Amendment to apply the Bill of Rights to the states, which has also played a big role in different groups' efforts to equalize our society, like with our African American population of the civil rights movement, our Hispanic American population, a lot of the difficulties that have been happening very recently and over to 2016. So the 14th Amendment is an amendment that really works hand in hand with this Bill of Rights and ensuring that every individual in the United States, even into those who are not in the United States under a quote, quote, legal status, are still guaranteed these rights under the 14th Amendment. Okay? So, The Bill of Rights, 14th Amendment, selective incorporation. So the Supreme Court initially resisted invoking selective incorporation. This was at a time when Jim Crow was more accepted in the South. It was kind of just thought of as a thing. The South is going to do this, we're just going to accept it. And the North had similar laws when slavery was first outlawed. Okay, this changed in the 1960s when the court began to assert and protect rights of the accused, especially through the civil rights movement. So a large issue we were seeing during this time frame in the 1960s was the issue of lynching, which is when basically we saw African Americans and Hispanic Americans being accused of different laws that many, or different crimes that many of them had not committed. They were not giving a trial. They were not giving what they should have been, the due process they should have been given as an American citizen. And instead, the crowd made themselves judge, jury, and executioner. Okay, so 1960s is whenever the Supreme Court really started to recognize the issue with lynching and the issue with the difference in rights that people were granted based on the color of their skin. Okay, so we have 4 of our First Amendment protections. Okay, one is the freedom of speech. You are free to say anything except if it is obscene, meaning very colorful, cuss word vocabulary, right? Slanders another individual or has a high probability of inciting others to take an imminent lawless action. In other words, trying to get people to violate the law. We also have freedom of the press, so you're able to write or publish almost anything except that is which is obscene, again that colorful vocabulary. Libel against a person, which we will get into definition on this in a little bit, seriously endangers military action or national security. In other words, especially in times of war, a member of the press cannot print out, create a story of what the exact movement of our military is going to be. That is, of course, going to put our military in danger and put our goals in danger. So our press does not have that right. And a high probability of inciting others to take imminent lawless action. Okay? Then we also have the freedom of assembly. So this is basically the freedom of protest. So one thing to note here, guys, is we do have the freedom of protest. However, this is limited in that you cannot become a very violent group of protesters. This only protects peaceful protest. It does not protect looting and destroying other people's property and that sort of thing. Okay, so we only have the freedom of assembly if it is a peaceful assembly. And you are protected from having religious beliefs of others imposed on you, meaning that you cannot have people forcing you to practice one religion or another. You're free to believe what you like. Okay? So, freedom of expression. This is our most democratic right. This is the one that almost everybody is familiar with. We have seen it evolve over time of what is acceptable and what is unacceptable. So, initially, the right of free expression was uncertain. So, we had the Sedition Act of 1798, which basically said that the deportation, fine, or imprisonment of anyone deemed a threat or publishing false, scandalous, or malicious writing against the government of the United States was illegal. As you can see here, though, under our Constitution, which at this point had been created quite recently, right? This was directly against the First Amendment, correct? Because someone was in danger if they even had a malicious writing, meaning that they're writing about reasons that they don't like the government or something they disagree with the government doing, or they're exaggerating government acts under this scandalous writing. And this was considered unacceptable at this time. It was taken out by Thomas Jefferson whenever he took on the presidency. Today, free expression is vigorously protected by the courts. Remember, this is to a certain extent because it can be denied if it endangers national security. So some of y'all might be doing the Patriot Act, as I saw on some of y'all's topics, for the cumulative essay. Remember, the Patriot Act gives the government a lot of power. Basically, the government can imprison you, they can tap your phones, they can tap your internet, if you are considered someone who could possibly be a danger to the nation. So there, if you notice, that definition is very broad, right? So because of that, it allows the government a very wide umbrella on which to work under. And so because of that, it has come into question many times on if it is actually protected under our Constitution / able to be implemented under our Constitution. You cannot wrongly damage others' reputation under that slander or that libel, which we'll talk about, or deprive others of their rights. So, free speech. Again, this is seeing a lot of evolution over time. So, Espionage Act and Schenck v. the United States. So, Espionage Act, this is during the time of World War I. Okay, remember, espionage is referring to spying, that sort of thing. So, national security needs early in the Cold War a change in the court's position in the 1950s has also played a huge role in the evolution of these efforts in trying to protect our country from the at that time the communist threat of the Soviet Union. There was again a very loose interpretation of the freedom of speech, and suspected communists oftentimes found themselves in very precarious situations whenever it came to the laws of the U.S. So the Espionage Act of 1917, it was passed after the U.S. entered World War I, and it prohibited obtaining information, recording pictures, copying descriptions of any information relating to the national defense, meaning relating to our military, with intent or reason to believe that the information may be used for the injury of the United States or to the advantage of a foreign nation. Remember this, and notice this looks very broad again, right? So, Schenck v. the United States, he was charged with violating the Espionage Act of 1917, which is why I say this is a very broad definition, after circulating material that was against the draft. Okay, he disagreed with the draft and the actions of the country with World War I and the path they were taking to obtain their victories in World War I, and he made his opinions known through circulating material, pamphlets of his disagreements with this draft. So traditionally, under our First Amendment rights, he should have been protected, correct? But under this Espionage Act, because it was such a broad umbrella under which the government could work under, Schenck was in danger of having himself imprisoned just for the act of stating his opinions about the draft. Okay? So, There are two tests that our Supreme Court uses when it comes to free speech. One is the clear and present danger test, and the other is the imminent lawless action test. So, the clear and present danger test says that the printed or spoken word may not be the subject of previous restraint or subsequent punishment unless its expression creates a clear and present danger bringing about a substantial evil. Okay, so this law, as you can see, again, is very, very broad, and because of that, it can be applied. It can also choose not to be applied to different actions. Okay, because they are very loose interpretations. Imminent lawless action, under this, speech is not protected by the First Amendment if the speaker intends to incite a violation of the law that is both imminent and likely. So, someone who is planning to overthrow the government, they would not be protected under the freedom of speech because it would incite imminent lawless action. Okay? So, hate speech is protected, but hate crimes are not. These are considered two different categories. So, an example of this, we had a Westboro Baptist Church protest, and it stated that it had banners that stated "Fag Troops" and "Thank God for Dead Shoulders" at a Marine's funeral. This Marine was part of a unit that accepted gay partnerships, their soldiers being homosexual, those sorts of things. And the Westboro Baptist Church did not agree with this. So at the Marines' actual funeral, they were putting up these different protests and these different posters. But it was upheld as constitutional because it was under the First Amendment. It was not imminent or lawless action or anything like that. Symbolic speech, which is action and not words, is protected, but less completely than verbal speech. So, for example, 1989, they ruled that the burning of a U.S. flag as a symbolic form of expression was lawful. Okay? So, some restrictions are allowed based on national security or disruptions to daily life. They must demonstrate that the event will cause harm and it lacks an alternative way to keep harm from happening. So, an example of this would be our 2020 protest, the Black Lives Matter protest, that tended to turn violent. When the protesters were peacefully protesting, they were protected. But whenever it turned into a movement where the protesters started turning violent, looting places, destroying places, that sort of thing, it then crossed a line. It was no longer protected under the free assembly. So the government can place time, place, and manner restrictions. So, for example, you cannot block an intersection during rush hour. Okay, you cannot go across the highway, which we have had protesters do this, go across the highway and completely block traffic. That is not considered a lawful demonstration of free assembly. You also cannot play speakers so loud that they can hear it miles away. In other words, it is a very noisy type protest. You cannot do that. So, press freedom and libel law. So, New York Times Company versus the United States and the publication of the Pentagon Papers. So, anti-war protesters obtained details that the U.S. government had deceived the public on aspects of the Vietnam War. So, under this condition of prior restraint. There's a government prohibition of speech or publication before it occurs. But that is an extreme burden of proof on the government. Why? Because the government has to prove without a shadow of a doubt why the information being leaked out or being known by the public would be a danger to the national government. Okay, they oftentimes in these situations default to the American people and not the government because of the danger of the government becoming too powerful with taking away different parts of free speech. So the government usually finds themselves having to give extreme statistics charts, absolutely no question why it would be a danger to the country. They cannot publish anything that gives details on current military operations or could endanger our troops. Okay? So, press freedom and libel law. So, we have libel and slander in here. So, libel is publishing material that falsely damages a person's reputation. You cannot do this. Oftentimes, you will see newspapers, regulated news sites are often monitored for these issues of libel and slander because these are not protected by the First Amendment. Slander is a spoken word. Okay, the way you can remember this is the S in slander, the S in spoken word, right? So this falsely damages a person's reputation. So libel against public officials requires actual malice and a knowing or reckless disregard for the truth. In other words, they have to publish it on purpose with or have not done their research well before it to count as libel or slander. Okay? So along with political expression, the First Amendment also protects religious freedom. Congress shall make no law respecting the establishment or religion or prohibiting the free exercise thereof. We do see some limitations on this. So there is something known as the Establishment Clause. So a government may not favor one religion over another or support a religion over no religion. We have this separation of the wall of separation and accommodation, often referred to as the separation of church and state. So this is a strict separation between the government and religion. So for example, you cannot have a nationally sponsored church within the nation. That would fall under this Establishment Clause, okay? And accommodation, this allows the government to aid religious activity if no preference is given towards a particular religion. The aid must be of a non-religious nature, but again, this is very broad, so it can swing either way depending on how you are arguing it. So, how was the question of accommodation decided? The court has frequently applied the lemon test. You might hear this whenever you buy a car. So whenever you first buy a car, you have a certain amount of time to be able to return that vehicle, known as the lemon test. Okay, I mean, it's a lemon. It's not good. It doesn't work. So the policy must have a non-religious purpose. The policy's principal or primary effect must be one that neither advances nor inhibits religion. And policy must not foster an excessive government entanglement with religion. Okay? So the Free Exercise Clause. The government is prohibited from interfering with the practice of religion. So government interference is allowed when the exercise of religious beliefs conflict with otherwise valid laws. So for example, human sacrifice. If a religion requires human sacrifice, under the Free Exercise Clause, that would not be allowed because it interferes with a law of you're not able to kill, right? So they're able to interfere if the exercise violates the national law, okay? So, Free Exercise Clause, we have a couple of controversial cases here. One is creationism taught alongside the theory of evolution in public schools. This was in 1987. The ruling was that schools could not teach creationism in the classroom because it was religious doctrine and not based on scientific research. The other one was the Burwell v. Hobby Lobby Stores 2014. Stores that only have a few owners are allowed to deny contraception as part of your health insurance based on religious grounds. So remember, under the Affordable Care Act that was passed under the Obama administration, insurance policies had to cover contraception. But in 2014, it was ruled that if the company is small enough, if there are a very small amount of owners, then they can count as more of a private enterprise, more of a private corporation, and therefore they are not required to provide contraception in their insurance if it was against their religious beliefs. So this was also expanded in 2020 to include more employers and religious groups based on conscientious and religious exemption. So we also have the Masterpiece Cake Shop v. Colorado Civil Rights Commission in 2018. This was when a cake shop denied a cake to a same-sex marriage couple. The ruling was that the Civil Rights Commission, basically the route they took to try and take action against this, had violated the baker's free exercise right by showing religious hostility towards the bakery in their deliberations. Therefore, the case was no longer valid, and the bakery was allowed to practice their own regulations and those sorts of things. It did not rule on anti-discrimination laws and free exercise clause, so it left it to open interpretation later. So the right to bear arms, there is a widely accepted view, especially in the South, that the Second Amendment blocked the federal government from abolishing state militias and also the carrying of firearms. This is known as our National Guard. Our National Guard is often controlled by our state leaders, our government, and is viewed as protected under our Second Amendment. Also in District of Columbia v. Heller, the court ruled that the Second Amendment protects an individual's right to possess a firearm. Okay, so over here, you see conflicting ideas of pro-life versus pro-choice, which we've also seen a lot in our more recent cases, especially in Texas, right? So it's very, very party-based on these beliefs. Okay, so this is the percentage agreeing that Roe v. Wade should be overturned and not overturned. 48% of Republicans say that it should be overturned. 11% of Democrats also say the same thing. But over here, 50% of our Republicans say it should not be overturned. And our Democrats, it's 87%. So as you can see, our Democrats are the ones who are usually dealing with cases like Roe v. Wade. Okay? With the Republican Party, depending on who you talk to and who you're which part of the party you are talking to, that sort of thing. People who are more focused on economic policy and not the social aspects. So within the Republican Party, you can see there's quite an even split. Okay, which is why you've also seen a lot of Republicans in an uproar over the heartbeat bill in Texas. But with the Democrats, you can see a very strong leaning towards protecting these stipulations under Roe v. Wade, which is why you've also seen a lot of Democratic action against the heartbeat law, especially as it has made its way to the Supreme Court. So, the right to privacy. Griswold v. Connecticut, 1965. Americans have a zone of privacy that the government cannot lawfully invade. It also legalized the use of contraception. Abortion was protected as a right of privacy in Roe v. Wade. We also have these subsequent Webster versus Reproductive Health Services, 1989, Planned Parenthood versus Casey, 1992, and Gonzalez v. Carhart, 2007, which established some restrictions to this Roe v. Wade ruling, which you can see over here. I have placed within the PowerPoint detailed outlines of these rulings for your reference. It also ruled over in 2003 that same-sex adults were eventually protected by the same right of privacy in Lawrence v. Texas in 2003. So prior to 2003, if a same-sex couple had been caught having relations, they could have been arrested, okay, facing fines, even jail time. But after this Lawrence v. Texas 2003, that was no longer the case, okay, and it was seen as this right to privacy. So, let's skip through the court cases for you. So, procedural due process, this is procedures that authorities must follow before a person can lawfully be punished for an offense. So things like Miranda rights, if a police officer does not read you your Miranda rights when you are being arrested, you can be arrested, or you can be let go on a technicality, okay? So if for some reason that were to happen to you, you need to tell your lawyer that you were not read your Miranda rights, which are now being caught by body cams and our police officers so they can actually check, and you would automatically be able to be let go. So we have the 4th, 5th, 6th, and 8th Amendments under here under these due process protections. One is the 4th Amendment, search and seizure. You're protected from unreasonable searches and seizures, although you forfeit the right if you knowingly waive it. This is also protected for your car, okay? Not only your house, but also your car. So if a cop wants to search your car, you can ask for a search warrant, okay? You're also protected from arrest unless authorities have probable cause to believe you have committed a crime. But again, they must read you your Miranda rights. You have a right to not say anything. Okay, oftentimes, when people are nervous, especially if they're being arrested, you tend to ramble, right? Some people tend to ramble, others tend to just stoic and very silent. But you're told you have the right to remain silent because technically you do not have to say a word, and you can leave all of the burden of proof onto the police officers, okay? You're also protected under this double jeopardy, so you cannot be tried twice for the same crime if the first trial results in acquittal. You're also protected with this due process, so you cannot be deprived of life, liberty, or property without proper legal proceedings. Remember, this only applies if it is not a suspected terrorist. If it is somebody who becomes a suspected terrorist, they lose this due process right here. The 6th Amendment, the counsel, you have a right to be represented by an attorney and can demand to speak first with the attorney before talking to anybody in law enforcement, which I highly suggest you should do. Prompt and reasonable proceedings, so you have the right to be arraigned promptly, to be informed of the charges, to confront your witnesses, basically be able to talk with your witnesses, and have a speedy and open trial by an impartial jury. So if anybody on the jury is suspected of, or you suspect them of not being impartial, such as maybe watching the news story on CNN or Fox, especially those that are very like to sensationalize the news, right? You suspect that, you have the right to question your jury members. 8th, bail. You are protected against excessive bail or fines and cruel and unusual punishment. So you're protected from cruel and unusual punishment, meaning that cops cannot torture you. Those kinds of things you see on TV, they are not allowed to do that. They cannot torture you and that sort of thing. but it does not protect you from the death penalty or a long prison term for a minor offense. So, unreasonable search and seizure. So, no police is allowed unless there is a probable cause that a crime occurred. The police will be granted a warrant. A requirement of a warrant has been upheld in cases involving cell phones and similar electronic devices. And remember, you have the right to ask for that warrant. And you have the right to not open your door until you have that warrant. Warrantless searches are allowed in some circumstances. We see this on public properties such as schools. School administrators can search for drugs and weapons in your lockers, in your cars, that sort of thing, because it is public property. Police roadblocks to check for intoxication are also allowed as long as the action is systematic and not arbitrary. In other words, if you feel like they're pulling over every single African American or every single Hispanic or even every single white person, if you feel like a racial group is being targeted with these roadblocks, you can bring that to the attention of your lawyer and they can use that in your trial. So the Fifth Amendment, protection against self-incrimination, means an individual cannot be compelled in any case to be a witness against themselves. So we see this in Miranda v. Arizona, 1966. There is no legal interrogation until the suspect has been warned or that his or her words could be used in evidence. Led to the formulation of the Miranda warning, which is that Miranda rights, they read you. So again, if you are picked up by the police, if they are searching your home, anything like that, never say a word until you have a lawyer, because you have the right to not say anything that could be used against you. Basically, leave all of the burden of proof on those officers. Okay? Here I have an outline of the case for you to review in your studies on Miranda v. Arizona. Okay, so trial phase, the right to a fair trial. So the Fifth Amendment means a suspect cannot be tried for a federal crime unless it is indicted by a grand jury. States are not required to use grand juries. This is why you often also see, especially on cases that result in the death penalty being exercised, people appealing up to the federal level because then they are guaranteed these grand juries. The Sixth Amendment, a right to legal counsel before and during trial. Criminal defendants also have the right to a system to a speedy trial and to confront witnesses against them. At the federal level and sometimes the state level, defendants have the right to a jury trial to be held by an impartial jury. And again, if this jury is ever at question of being impartial, it can result in an acquittal. So those allegations, those questions are often met with seriousness because it can result in a case being completely null and void. So, the right to a fair trial, the exclusionary rule, evidence obtained in violation of the defendant's rights cannot be used. Okay, we have these three exceptions here. One is the good faith exception. So, if police believed they were following proper procedures, they can use the evidence. If it was an inevitable discovery, meaning that if other evidence would have led to the same discovery, they can use it. And the plain view exception, meaning that if they found the object in plain sight, then they could also use it. But again here, especially with this good faith exception, these tend to come under question a lot by legal counsel. So, the Eighth Amendment prohibits cruel and unusual punishment. Okay, things like being tortured using medieval torture devices, being deprived of food or water for a long period of time, being deprived of sleep for a long period of time. These are all cruel and unusual punishment. Okay, so the tests consider whether it is disproportionate to the offense, meaning is what you're using really on par with the level of the offense, or if it violates fundamental standards of good conscience and fairness and is unnecessarily cruel. The Supreme Court generally allows states to decide punishment, but it has limited some aspects. It's banned the death penalty for minors and the mentally ill, and it has banned life without parole for juveniles, and it extended this protection to juveniles convicted before that ban was put into place. So in other words, these juveniles who were held before that law was passed were allowed to be acquitted. They were allowed to leave. So there is no constitutional guarantee of appeal, but the federal government and the states all allow at least one appeal. Federal law bars a second federal appeal by a state prison inmate in most instances. It's very rare that you're able to get that second appeal. So, Supreme Court rulings have affected police practices. So that Miranda v. Arizona, that's the creation of the Miranda rights. Constitutional rights applied unevenly, so racial profiling, targeting individuals from minority groups. Minorities are also more likely to be victims of police violence, as we know and have seen. And tough sentencing policies are popular with voters, but prison overcrowding is an issue, especially in states like Texas, where we have one of the highest rates of imprisonment for our people. Okay, we have a lot compared to the percentage of our society, our percentage of our population of Texas. A high percentage of that population is in prison in Texas. So incarceration rates, so as you can see, Texas over here, we have a very high incarceration rate, which is another reason why a lot of our budget goes to jails and prisons and those sorts of things. As you can see, this is a very popular practice among these southern states over here, especially in places like Georgia. If you ever seen First and Last Day on Netflix, that sort of thing, it takes place over in Georgia. The northeastern states, these northern states over here, California, so states that some, not all, some states that tend to be Democrat tend to also have a lower imprisonment rate than the more solidly Republican states, with the exception of Texas. Texas is a swing state, so we'll see if that results in any changes in the next coming of years. So incarceration rates by country. So as you can also see, the United States has one of the highest incarceration rates in the entire world. Okay, so this does play a huge role in our national politics and does come up a lot. So in times of war, the courts have upheld policies that would not otherwise be permitted. So for example, World War II, a lot of people think that the Germans were the only ones who used concentration camps. This is not true. The Spanish used them over in Cuba, in the Philippines. We saw it with, of course, Germany. We've seen it with the United States. The United States also held Japanese Americans based just on the fact that they were Japanese. Okay? Very poor conditions within these camps that resulted in a lot of starvation, people dying, and that kind of thing. So, in times of war, we often find ourselves changing what we believe to be acceptable, or people who are, quote, quote, a threat to the country. We saw this in the during the early 2000s with the question of terrorism and our Islamic population. We saw a lot of issues with that, with hate crimes, racial profiling, all those sorts of things. We're seeing that now with Russian citizens. It's happening again. So there are a lot of issues that are usually very racial based during times of war, and it usually corresponds with the country that we are currently at odds with or at war with. So here's a court case for you to read over Korematsu versus the United States, 1944, which legalized those concentration camps. So after the attacks of 9/11, the Bush administration announced a policy of detaining enemy combatants, and this was under the Patriot Act. The Supreme Court ruled that detainees have the right to challenge their Guantanamo Bay detention in U.S. courts, and this was under Hampton v. Rumsfeld 2006, which you can see here for your review. So the USA Patriot Act gave the government additional tools for combating terrorism. This is whenever we saw the National Security Agency, NSA, being created. This is whenever we saw warrantless wiretapping on your internet and your phone, which can still happen. It's been said it's unlawful, but it does still happen. The program was leaked by Edward Snowden in 2013. The federal appellate court ruled the NSA program unlawful, but the Congress passed revised legislation to authorize a more limited surveillance program with greater oversight, which is why I said that it does still happen. And they had to obtain a warrant to be able to access phone records, which again, if they have probable cause, they can skip a step and access the phone records. So the courts in free society, last slide of this chapter. So Americans embrace freedom of expression as an abstract virtue. In other words, this has been something that's been part of our country since its inception. It is, since the beginning, our country has very much appreciated freedom of expression because it was not allowed under Great Britain when we were under Great Britain. Americans favor limits to freedom of expression in particular instances, especially in times of war. And the judicial system has been the one that has often stepped in, our Supreme Court system has been the one that has often stepped in whenever there came a question if this law or this issue was a danger to our rights. Okay, under all of the different tests that we talked about today. Okay, so that's it for chapter 4.